Appendix C. Paternity Probabilities. Attack and Rebuttal. Reservations about the paternity probability. Michael Aiken, Ph.D. Samaritan Health Service, Phoenix, Arizona. The victim of a hit-and-run incident testifies that he is certain that he remembers one letter and one number on the license plate of the car that hit him. He reports that the last of the three letters was A, and the last of the three numbers was 3. He cannot recall the other letters and numbers. The woman charged in the case drives a car with plate JKA 123. The prosecuting attorney presents an expert witness who testifies that on the basis of this evidence alone, the probability that the accused woman committed the hit-and-run is 0.9962, or 99.62%. The computation is simple. If the woman is guilty, then the probability that her plate would match the recall of the victim is 1, or 100%, because the victim is so sure of his testimony. On the other hand, if the woman is innocent and was in effect selected for accusation at random, then the probability that her plate would match the victim's description is 1/260. This latter figure is calculated by observing that the chance of a matched letter is 1/26. The chance of a matched number is 1/10, and since the two outcomes are independent, their probabilities may be multiplied to form the chance of their joint occurrence. Finally, we compute the guilt index by dividing the former probability by the latter, GI equals 260, and then the probability of guilt by the formula PG equals GI/1 plus G1, equals 0.9962. The expert witness testifies that the calculation is mathematically correct. It follows from Bayes' theorem, and based on empirical facts. The Department of Licenses reports that except for a very small fraction of vanity plates, all letters and all numbers are equally likely on a randomly chosen license plate. He may also report that it is methodologically identical to the paternity probability calculation that was popularized in the 1970s and has come to be accepted in many courts. Although this little example may appear to have no relationship to paternity, it is true that virtually all experts in the area of paternity testing are agreed that the fundamental logic of the preceding probability calculation is sound. To a few of us, however, it seems as though the paternity probability, like the above probability of guilt, risks overstating the evidence on which it is based, and we have expended some modest effort in trying to explain why this is so. Direct v. Circumstantial evidence. Direct evidence is evidence that, if believed, requires no further argument in order to establish the fact at issue. If the victim had seen the face of the woman as she drove the car that hit him and had recognized her in court, this would be direct evidence. Circumstantial evidence is evidence that, if believed, does require a further argument in order to establish the fact at issue. The victim's partial recall of a license plate matching that of the accused woman is circumstantial evidence. That a particular man is genetically capable of having produced a given child is also circumstantial evidence. The probability of guilt claims to be direct evidence. After all, if a scientifically determined probability of the woman's guilt is 0.9962, then it would be irrational to argue that she is innocent. The probability of paternity also claims to be direct evidence. The conclusion must be that the reasoning behind the probability calculation provides the additional argument necessary to transform circumstantial into direct evidence. It is necessary to examine this reasoning before accepting the argument. What do scientists do? The problem of determining whether a given man is the father of a given child bears similarity to the medical problem of deciding whether or not a given individual suffers from a particular disease. In each case there are two alternatives: he is the father or he isn't, the subject has the disease or doesn't, and a test is available that behaves differently depending on that of the alternatives is true. This being so, it is informative to discover how the medical profession handles the diagnostic problem. The methodology is well developed and consists of carrying out a study in which a number of individuals known to have the disease are tested, and then a second group of individuals known not to have the disease are similarly tested. The figures reported from such a study are the true positive rate, which is the fraction of all non-diseased individuals who test negative. To the extent that these two rates are high, the test is regarded as being a valid indicator of the presence or absence of disease, and its results are relied on. The logic is quite simple. No matter whether the person has the disease or not, the test has a large probability of correctly signifying the presence or absence of disease, and therefore we should accept its conclusion. No probability of disease or non-disease need be computed, because to do this computation, using Bayes' theorem, requires an assumption, the prior probability of disease, that is less closely connected to the particular person than are the test results. In paternity testing, the true negative rate is called the probability of exclusion, which is the probability that a non-father would be excluded by the blood tests. Because of advances in identifying multiple systems, it has become possible to design a battery of tests with true negative rates above. The true positive rate is so seldom discussed in the paternity testing literature that it does not have a special name. It has probably never appeared on any laboratory report, and there is some question whether a typical serological laboratory even knows what the true positive rates of its tests are. The reason for this may be that the true positive rate, probability of not excluding a true father, is implicitly regarded as 100%. Among the possible arguments that a lower figure is more appropriate are, 1. The possibility of mutations or other genetic anomalies, and 2. The lack of perfect reliability of blood tests. As to the first, the probability of a mutation is regarded as being very small and is typically neglected. However, since one often encounters small probabilities in paternity calculations, this does not seem to be a sufficient reason to ignore it. The second is more important, because it may involve larger probabilities and may be less accurately known. Some laboratories do not publicly admit any error rate in their tests, while some others report rates of 1% to 1.5%. It is usually unclear what the rates refer to or how they are ascertained. This point is of some significance, because it seems unreasonable for a laboratory whose test reliability, on a per-case basis, is 98.5% to report paternity probabilities in excess of this figure. It is to be emphasized that the true positive and negative rates are not only properties of the serological tests but also of the laboratories that carry them out. One final advantage of true positive and negative rates is that it is possible to obtain accurate empirical estimates of them apart from any reference to paternity disputes and with a minimum of assumptions about population genetics. In order to empirically validate paternity probabilities, it would be necessary to mount a costly and very difficult direct study of paternity cases themselves. It is unlikely that this will ever be done. In addition to the assessment of its own internal error rates, a laboratory should be required to adhere to the same guidelines that are customarily imposed in blinded clinical studies. Many laboratories, perhaps most of them, do not do this. Comparison of probabilities. Granted that the production of a paternity probability based on genetic evidence is a worthy goal, there are some choices among methods by which it could be calculated. The customary paternity probability calculation is one method, but it is worthwhile to consider at least one alternative. A key ingredient of the paternity probability is the probability that a man of the alleged father's phenotype would, in conjunction with a woman of the mother's phenotype, produce offspring with the child's phenotype. We shall call this the joint offspring probability of the mother and alleged father. This probability is easy to compute but difficult to interpret by itself. What is required is some other probability, or probabilities, with which it can be compared. It would seem to be apparent that the most relevant probabilities for comparison would be the joint offspring probabilities of other men who might plausibly be considered as possible fathers. If blood from these other plausible fathers could be drawn, then their joint offspring probabilities could be compared to those of the alleged father, and a probability of paternity be established for each man. This would use the Bayesian methodology that has been accepted by paternity testers. It would provide a complete set of genetic evidence for the computation of paternity probabilities. Nearly all paternity probabilities are obtained without this complete set of evidence. The comparison probability that is actually calculated is the probability that a woman of the mother's phenotype would produce offspring of the child's phenotype. We shall call this the mother's offspring probability. In order to get around the difficulty that the true father's phenotype would be unknown in this case, it is assumed that the father's genes were obtained by a random draw from some large population. This is generally called the random man hypothesis. Consider these figures from an actual case. The joint offspring probability of the mother and alleged father was 0.0006. And the mother's offspring probability was 0.00007, minus 85.7. and the paternity probability was. The paternity index, pi, was then 0.006/.0007857/86.7 equals 0.989. It was extremely unlikely in this case that the alleged father produced the child 0.006, but the paternity probability was high, 0.989. The reason it was high is that, even though the chance of the alleged father producing the child was small, the probability of a random man having produced it, 0.00007, was much smaller. Comparing these probabilities by forming their ratio, 85.7, led to the result. The crux of the issue is whether this comparison is reasonable. Paternity testers argue that if the alleged father were not the true father, then the only reasonable way to compute the mother's offspring probability is by a genetic random draw. Although this argument is true as far as it goes, it does not address the question whether the most reasonable calculation one can carry out is sufficiently reasonable to form the basis of a judgment. It does not weigh the cost of obtaining the blood types of the other plausible fathers against the risk of producing a misleading probability without them. Actual Bayesian decision-making would take these costs and risks into account and could lead to the conclusion that further evidence is required before a decision should be reached. Paternity testers use a simplified version of Bayesian methodology that ignores this issue. Responsible paternity testers have repeatedly emphasized that additional factors need to be considered in conjunction with the paternity probability, but it is not clear that their warnings find much expression in its day-to-day application. Some proponents of the paternity probability would evidently go so far as to say that once it reached some very high value, the introduction of additional evidence becomes unnecessary. This amounts to asserting that genetic evidence alone is sufficiently complete for a judgment, which is a determination that properly belongs in the sphere of law, not genetics. If the paternity tester's rationale for computing the PL ratio were generally acceptable, then it would not be particularly difficult to convert circumstantial evidence into direct evidence in a wide variety of situations. The reason is that if one computes the probability of an outcome using much evidence, a proximal probability, and then recomputes it using little evidence, a distal probability, then the former will virtually always be larger than the latter. In trying to forecast human events, if one takes enough aspects of a situation into account, then all possible outcomes are unlikely. Even the outcome that eventually happens would have been given a small distal probability. However, as one draws closer to the event and becomes aware of more and more of its aspects, the proximal probability of the actual outcome becomes larger. Thus, once we know that the alleged father is not excluded from paternity, we can calculate a joint offspring probability, proximal, that will nearly always be much larger than the mother's offspring probability, distal. The difficulty that arises when Bayesian methods are applied to proximal and distal probabilities has been raised as an objection to routine, unconsidered employment of these methods. On the other side, the comparison of proximal and distal probabilities only becomes an issue after the alleged father has not been excluded from paternity. It is a powerful theoretical property of genetic testing that it should have large true positive and true negative rates. Once the accused man has not been excluded, there is clearly genetic evidence that he is the true father. Nevertheless, there does not seem to be any overpowering reason to follow a legitimate test, finding that the accused man is not excluded, by a further test that inappropriately compares proximal and distal probabilities. Probabilities without evidence. The most persistent objection that non-Bayesian statisticians have brought against Bayesian methods is that the Bayesian must at some point introduce prior probabilities based on no evidence. The Bayesian counterargument is that, as empirical evidence accumulates, the choice of the prior probabilities has a negligible influence on the final decision. The paternity testers assign prior probability of 0.5 to each of the two alternatives, that the alleged father is the true father or that he is not. They justify this by saying, 1. That any other assignment of prior probabilities favors one side or the other, and 2. That the actual fraction of mothers who correctly identify fathers is higher, 3 of 4, so that the alleged father cannot complain that the prior disfavors him. With regard to the first justification, we have seen that a complete genetic analysis of paternity would consider all plausible fathers, and it seems reasonable that an assignment of prior probability that is fair to all of them would give each the same prior probability of being the true father. The paternity tester's adoption of a 0.5 prior for the alleged man is equivalent to the assumption that there is only one other plausible father. No doubt this is reasonable in some cases, but again one needs to ask whether it is better to assume only one other plausible father or to actually find out how many there are. What this point illustrates is that it is very difficult to produce a paternity probability that is based strictly on genetics, with no further non-genetic assumptions. With regard to the second justification, it is fairly clear to the legal profession that historical conviction rates are not admissible as evidence in a particular case. Even if 99% of all murder trials had resulted in conviction in a jurisdiction, this would not lead to the decision to declare all future trials irrelevant and proceed immediately to the highly probable guilty verdict. Whether the asserted 75% identification rate of true fathers in paternity cases should be allowed to influence the allocation of prior probabilities is a question that should be decided by jurists, not geneticists. Conclusion: there is no question that genetic tests are immediately relevant in paternity cases, nor is there any serious dispute that the laboratory tests are scientific in character. There is, however, some controversy over how the laboratory results should be presented. Since the science of genetic testing has progressed to the point that the information it can bring to bear on paternity cases is strong and convincing, it seems unnecessary to risk calling that information into question by reporting it in a manner that is subject to challenge. There does not seem to be any compelling reason to depart from the model that is usual in reporting the results of a medical test. One need only quote the true positive and true negative rates of the test and the result in the particular instance. If this presentation of evidence is not persuasive, then no useful purpose would be served by carrying out dubious comparisons of proximal and distal probabilities. Consumers of the products of serological testing should be less concerned that the laboratory can calculate an impressive paternity probability and more concerned that it can provide convincing, accurate estimates of the true positive and true negative rates of the tests it actually performs, including an assessment of its unreliability or error rates. Guidelines for reporting estimates of probability of paternity. Richard H. Walker. Some fallacies in the computation of paternity probabilities by Michael Aiken. 1. Purports to discredit the guidelines for reporting estimates of probability of paternity established by the American Association of Blood Banks. 2. Dr. Aiken's assumptions, reasoning, and statements require a response since they challenge the fundamental logic employed in the laboratories of the United States, Europe, and Scandinavia in calculations and the reporting of results in non-exclusion cases. The recent alarming increase in illegitimate births in the United States has intensified interest in establishing paternity of these infants. Blood tests offer the best means of providing valuable objective evidence for or against paternity of men alleged to be fathers. An international conference was convened by the American Association of Blood Banks, AB, at Early, Virginia, in May 1982 under a grant from the Office of Child Support Enforcement of the U.S. Department of Health and Human Services in order to develop consensus in the method of calculating and reporting the probability of paternity when there is a failure to exclude the alleged father in paternity disputes. The AB perceived a need for a uniform method to enhance credibility and communication to the courts. The guidelines were developed after hearing various proposals and arguments from experts in the field. 8 experts in paternity testing from Europe, Scandinavia, and England were invited to participate together with several workers from the United States in this conference. In addition, 2 consultants in population genetics and biostatistics were invited to critique the presentations. These 4 consultants were selected because they were not involved in parentage testing and therefore could take an impartial look at what was presented and the logic of the calculations. A number of other diverse, invited experts in mathematics, jurisprudence, and genetics participated. Dr. Aiken was one of the contributors to this conference. The invited experts were given one test case to evaluate in which there was no exclusion of the alleged father. Gene, haplotype frequency tables were supplied for the calculations. The test case involved a total of 6 genetic systems and included systems in which the maternal and paternal gene contributions to the child were obvious as well as systems where alternative possibilities existed. The HLA system analysis was complex since blanks existed at both the A and B loci in the child. All 14 participants who responded to the test case obtained the same result, although different styles and logic were employed. This achievement is of great significance since it reflects international unanimity in terms of the mathematical result. The rebuttal to Dr. Michael Aiken's article, "Some Fallacies in the Computation of Paternity Probabilities," was submitted in the form of a letter to the editor of the American Journal of Human Genetics in October 1984 and subsequently appeared in the journal in August 1985. Written permission has been received by the author, Dr. Richard H. Walker, William Beaumont Hospital, Royal Oak, Michigan. Various proposals and methods were discussed and debated during the conference. A strong case for reporting the probability of paternity based upon the failure to exclude after using multiple systems was proposed by Dr. C.C. Lee. 3. This suggestion was given very deliberate consideration by the committee and was recognized as having great merit. After a review of this and other proposals and suggestions, the Committee on Parentage Testing of the AB developed the guidelines for use by laboratories in the United States. The guidelines have been subsequently approved by the Board of Directors, American Association of Blood Banks, Section of Family Law, American Bar Association, and Council on Scientific Affairs, American Medical Association. These guidelines do not require the reporting of any specific numerical expression, but they do indicate that some mathematical estimate of the probability of paternity should be calculated from the observed phenotypes of the mother, child, and alleged father when there is a failure to exclude. The paternity index, BI, referred to by Aiken as the likelihood ratio, LR, has become established as the basic mathematical expression employed by most laboratories in the United States and Europe. This value can also be transformed into a percentage expression using 0.5 as a prior probability value. This percentage expression, the probability of paternity, is the estimate most familiar to the legal community and the courts. The calculation is based entirely upon the genetic markers identified in the trio and does not consider any non-genetic evidence in the case such as access, impotency, sterility, and other men who could be the biological father. Aiken's paper considered 3 basic fallacies in the probability of paternity statement used by laboratories engaged in paternity testing. Dr. Aiken's first argument is that the statement of probability of paternity is a fallacy since the figure is not, in fact, the probability that the alleged father is the true father. The PL is a statement of probabilities in the form of a ratio that expresses the probability that a man with the same phenotype as the alleged father is the biological father of a child with the phenotypes observed when he is compared to an untested man from the same population. The assumption is made in one-man cases that the biological father was either the alleged father or an untested man, often referred to as a random man. As Dr. Aiken points out, the PL is not exclusive for the alleged father but applies equally to all men of the same phenotype as the alleged father. Such a consideration is implicit in the definition of the BI, 2, pp. 475 and 656. However, Dr. Aiken avoids pursuing this matter to its logical conclusion. The relevant sequel to this statement is the question: how many men are there who have the same phenotype as the alleged father? The answer depends upon the extent of genetic testing performed in each case under consideration, but the value is frequently less than 1 in 100,000, 2, p. 31. The second criticism of Dr. Aiken involves factors that are unknown to the testing laboratory and therefore cannot be used in a calculation. Dr. Aiken has indicated that even in one-man cases there may be other plausible fathers beyond the man named by the mother, that is, the alleged father being tested. This may certainly be true, but such information is unknown to the laboratory and therefore cannot be used in a calculation. Thus, a neutral prior probability is used in the calculation. The reported probability of paternity can be adjusted up or down based upon the weight of other evidence in the case. However, such an adjustment is not in the province of the laboratory scientist. This is the responsibility of the judge or jury charged with evaluating all of the evidence in their case. The calculation does, however, consider all possible, compatible, fathers in the denominator of the PL by selecting the untested man using gene frequencies established from a large population. The gene frequencies utilized are based on the racial origin rather than geography and are used in both the numerator and denominator of the PL. In those rare cases where more than one man is tested, experience has demonstrated that it is usual for all but one man to be excluded. When more than one man is not excluded in a single case, a calculation of the relative probability of paternity can be given for each non-excluded man. Formulas for such calculations have been published by Professor K. Hummel. However, the question of access to the mother, frequency of intercourse, and potency and fertility of each plausible father constitute additional variables that would also be unknown and therefore could not be accurately quantitated. Although the race of the biological father is unknown, it is important for the laboratory to use gene frequencies in the calculation from a carefully selected and large sample of the population of the same race claimed by the mother and alleged father. Gene frequency tables have been published by the AB. 5, p. 29 ff, for use by parentage testing laboratories in making these calculations. Dr. Aiken's third challenge involves the estimation of genotype frequencies within a given phenotype when silent alleles may be present. He asserts that genotype frequency assignments within such phenotypes represent speculation about random draw. In practice, such assignments are based upon published tables of gene frequencies that are then utilized in the Hardy-Weinberg formula to estimate genotype frequencies within phenotypes. Fundamental genetic principles are applied to the calculations of both genotype frequencies and gamete frequencies. Dr. Aiken cites the example of a group B mother with a no child and points out that the biologic father must contribute a no gene. He then states that whether a man additionally carries A or B or another O gene is irrelevant to paternity. While it is true that the only requirement for a man to be the biologic father is to carry a no gene, it is not true that the chances of men whose phenotypes are A, B, and O all have equal chances of transmitting a no gene. The PL values for these phenotypes are as Dr. Aiken indicates, 0.63 for A, 0.72 for B, and 1.51 for O. This observation clearly demonstrates that the group O alleged father is over 2 times more likely to contribute a no gene than is a group A alleged father. In fact, the O alleged father cannot contribute a wrong gene while the group A alleged father has a 58% chance of transmitting an A gene that is incompatible with paternity. An obvious implication by Dr. Aiken would be that genetic counseling is of no value in instances where the phenotype does not reflect the genotype. A random woman is not equally likely to produce a hemophiliac son as is a woman known to be the sister of a hemophiliac. However, both carry normal genes. Neither are A, B, and O fathers equally likely to produce O children. Their relative chances of producing an O child can be calculated using the basic principles of population genetics. Of course, any of them could produce such a child, but the probabilities are not the same. The fact that the LR may be enormous does not necessarily mean that it is incorrect, but rather may indicate a true statement of the probabilities. We agree that family studies would be of value in yielding an improved estimate of the probability of paternity. Such studies should not be limited to the alleged father or plausible fathers, but may also be informative and helpful when the mother's family is studied. Major problems, however, are state statutory laws, cooperation, and illegitimacy. 1950, Congress passed the first federal child support enforcement legislation by adding Section 402(11) to the Social Security Act, 42 U.S.C. 602(11), requiring state welfare agencies to notify appropriate law enforcement officials upon providing aid to families with dependent children, AFDC, with respect to a child who was abandoned or deserted by a parent. Also that year, the National Conference of Commissioners on Uniform State Laws and the American Bar Association approved the Uniform Reciprocal Enforcement of Support Act. Subsequent amendments to this act were approved in 1952, 1958, and 1968. 1965. Public Law, PL. 8997 allowed a state or local welfare agency to obtain from the Secretary of Health, Education, and Welfare, the address and place of employment of an absent parent who owed child support under a court order for support. 1967, PL 9248 allowed states to obtain from IRS the addresses of absent parents who owed child support under a court order for support. In addition, each state was required to establish a single organizational unit to establish paternity and collect child support for deserted children receiving AFDC. States were also required to work cooperatively with each other under child support reciprocity agreements and with courts and law enforcement officials. 1975. After 3 years of congressional attention to child support enforcement issues, PL 93-647 was signed into law on January 4, 1975, creating, inter alia, Part 500 of Title IV of the Social Security Act, Sections 451, 8 Sec. 42 U.S.C. 651 et Sec. The child support enforcement provisions of PL 93-647 are, in brief, as follows. The Secretary of Health, Education, and Welfare, now the Department of Health and Human Services, DHHS, has primary responsibility for the child support enforcement program and is required to establish a separate organizational unit to operate the program. Operational responsibilities include 1. Establishing a parent locator service, 2. Establishing standards for state program organization, staffing, and operation to assure an effective program, 3. Reviewing and approving state plans for the program, 4. Evaluating state program operations by conducting audits of each state's program, 5. Certifying cases for referral to the federal courts to enforce support obligations, 6. Certifying cases for referral to the IRS for support collections, 7. Providing technical assistance to states and assisting them with reporting procedures, 8. Maintaining records of program operations, expenditures, and collections, and 9. Submitting an annual report to the Congress. Primary responsibility for operating the child support enforcement program is placed on the states pursuant to the state plan. The major requirements of a state plan are that, 1. The state designate a single and separate organizational unit to administer the program. 2. The state undertake to establish paternity and secure support for individuals receiving AFDC and others who apply directly for child support enforcement services. 3. Child support payments be made to the state for distribution. 4. The state enter into cooperative agreements with appropriate courts and law enforcement officials. 5. The state establish a state parent locator service that utilizes both state and local parent location resources and federal parent locator service. 6. The state cooperate with any other state in locating an absent parent, establishing paternity, and securing support. And 7. The state maintain a full record of collections and disbursements made under the plan. Procedures for the distribution of child support collections received on behalf of families receiving AFDC were set out. Incentive payments to states for collections made on AFDC cases were created. Monies due and payable to federal employees became subjected to garnishment for the collection of child support. New eligibility requirements were added to the AFDC program, which required each applicant for, or recipient of, AFDC to make an assignment of support rights to the state, to cooperate with the state in establishing paternity and securing support, and to furnish his or her social security number to the state. The effective date of PL 93-647 was to be July 1, 1975, except for the provision regarding garnishment of federal employees, which became effective on January 4, 1975. Several problems were identified prior to the effective date, though, and Congress passed PL 9446 to extend the effective date to August 1, 1975. In addition, PL 9488 was passed in August 1975 to allow states to obtain waivers from certain program requirements under certain conditions until June 30, 1976. and to receive federal reimbursement at a reduced rate. This law also eased the requirement for AFDC recipients to cooperate with state child support enforcement agencies when such cooperation would not be in the best interests of the child. It also provided for supplemental payments to AFDC recipients whose grants would be reduced due to the implementation of the Child Support Enforcement Program. 1976. Effective October 20, 1976. State employment agencies were required to provide absent parents' addresses to state child support enforcement agencies, PL 94 566, 1977. PL 9530, effective May 23, 1977, made several amendments to Title 4D, provisions relating to the garnishment of a federal employee's wages for child support were amended to 1. Include employees of the District of Columbia. 2. Specify the conditions and procedures to be followed to serve garnishments on federal agencies. 3. Authorize the issuance of garnishment regulations by the three branches of the federal government and by the District of Columbia. And 4. Define further certain terms used. Section 454 of the Social Security Act, 42 U.S.C. 654. Was amended to require the state plan to provide for bonding of employees who receive, handle, or disperse cash and to ensure that the accounting and collection functions be performed by different individuals. The incentive payment provision, under Section 458A of the Social Security Act, 42 U.S.C. 658A, was amended to change the rate to 15% of AFDC collections, from 25% for the first 12 months and 10% thereafter. The Medicare-Medicaid Anti-Fraud and Abuse Amendments of 1977, PL 95-142, effective on October 25, 1977, established a medical support enforcement program, under which states could require Medicaid applicants to assign to the state their rights to medical support. State Medicaid agencies were allowed to enter into cooperative agreements with any appropriate agency of any state, including the 4D agency, for assistance with the enforcement and collection of medical support obligations. Incentives were also available to localities making child support collections for states and to states securing collections on behalf of other states. 1978. The Bankruptcy Reform Act of 1978, PL 95-598, which was signed into law on November 6, 1978, repealed Section 456B, of the Social Security Act, 42 U.S.C. 656B, which had barred the discharge in bankruptcy of assigned child support debts. The Federal Bankruptcy Act was subsequently repealed as of October 1, 1979, and replaced by a new Uniform Law on Bankruptcy. Section 456H of the Social Security Act was reenacted by Section 2334 of PL 9735, 1980. Section 2 of PL 96-178 extended until March 31, 1980, Federal Financial Participation, FFP, for non-AFDC services, retroactive to October 1, 1978. The Social Security Disability Amendments of 1980, P. L. 96-265, were signed into law on June 9, 1980, increasing federal matching funds to 90%, effective July 1, 1981, for the costs of developing, implementing, and enhancing approved automated child support management information systems. Federal matching funds were also made available for child support enforcement duties performed by certain court personnel. In another provision, the law authorized the use of the IRS to collect child support arrearages on behalf of non-AFDC families. Finally, the law provided state and local 4D agencies access to wage information held by the Social Security Administration and state employment security agencies for use in establishing and enforcing child support obligations. The Adoption Assistance and Child Welfare Act of 1980, P. L. 96-272, contained 4 amendments to Title 4D of the Social Security Act. The law made FFP for non-AFDC services available on a permanent basis. It allowed states to receive incentive payments on all AFDC collections as well as interstate collections. Third, as of October 1, 1979, states were required to claim reimbursement for expenditures within 2 years, with some exceptions. The fourth change postponed until October 1980. The imposition of the 5% penalty on AFDC reimbursement for states not having effective child support enforcement programs. 1981. The Omnibus Reconciliation Act of 1981, PL 9735, added 5 amendments to the 4D provisions. First, IRS was authorized to withhold all or a part of certain individuals' federal income tax refunds for collection of delinquent child support obligations. Second, 4D agencies were required to collect spousal support for AFDC families. Third, for non-AFDC cases, 4D agencies were required to collect fees from absent parents who were delinquent in their child support payments. Fourth, child support obligations assigned to the state no longer were dischargeable in bankruptcy proceedings. Finally, the law imposed on states a requirement to withhold a portion of unemployment benefits from absent parents delinquent in their support payments. 1982. The Tax Equity and Fiscal Responsibility Act of 1982, PL 97-248, was signed into law on September 3, 1982, and included the following provisions, which affected the 4D program. FFP was reduced from 75 to 70%, effective October 1, 1982. Incentives were reduced from 15 to 12%, effective October 1, 1983. The provision for reimbursement of costs of certain court personnel costs that exceed the amount of funds spent by a state on similar court expenses during calendar year 1978 was repealed. The mandatory non-AFDC collection fee imposed by PL 9735 was repealed, retroactive to August 13, 1981. P.L. 97-248 allowed states to elect not to recover costs, or to recover costs from collections or from fees imposed on absent parents. Another provision clarified states' authority to collect spousal support in certain non-AFDC cases. As of October 1, 1982, members of the uniformed services on active duty were required to make allotments from their pay when support arrearages reached the equivalent of a 2-month delinquency. Also beginning October 1, 1982, states were allowed to reimburse themselves for AFDC grants paid to families for the first month in which the collection of child support is sufficient to make a family ineligible for AFDC. The Omnibus Budget Reconciliation Act of 1982, PL 97-253, effective September 8, 1982, provided for the disclosure of information obtained under authority of the Food Stamp Act of 1977 to various programs, including state child support enforcement agencies. Title X of the Uniformed Services Former Spouses Protection Act, PL 97-252, signed into law on September 8, 1982, treats military retirement or retainer pay as property to be divided by state courts in connection with divorce, dissolution, annulment, or legal separation proceedings. 1984. The key provisions of PL 98-378, the Child Support Enforcement Amendments of 1984, require critical improvements to state and local child support enforcement programs in 4 major areas. Mandatory practices. All states must enact statutes providing for the use of improved enforcement mechanisms, including 1. Mandatory income withholding procedures, 2. Expedited processes for establishing and enforcing support orders, 3. State income tax refund interceptions, 4. Liens against real and personal property, security or bonds to assure compliance with support obligations, 5. Reports of support delinquency information to consumer reporting agencies. In addition, state law must allow for the bringing of paternity actions any time prior to a child's 18th birthday, and all support orders issued or modified after October 1, 1985, must include a provision for wage withholding, federal financial participation and audit provisions. The Act encourages greater reliance on performance-based incentives by reducing federal matching funds by 2% in federal fiscal year 1988, to 68%, and another 2% in fiscal year 1990, to 66%. Federal matching funds at 90% are available for the development and installation of automated systems to improve required procedures, and, for the first time, computer hardware purchases can be matched at this higher rate. The Graham-Rudman-Hollings legislation may impact these percentages. Starting October 1, 1985, states will receive an incentive minimum of 6% for both AFDC and non-AFDC collections. These percentages can increase to as much as 10% for both categories for very cost-effective states. But a state's non-AFDC incentive payments are limited by the amount of incentives available for AFDC collections. The law further requires states to pass incentives through to local child support enforcement agencies where these agencies have participated in the costs of the program. The Act modifies the requirement of auditing each state annually to one of auditing each state at least once every 3 years. The Act also alters the focus of the audits to the extent that, beginning with the FY 86 audit period, states' effectiveness will be evaluated on the basis of program performance as well as operational compliance. Graduated penalties of from 1 to 5% of total payments to the state under the AFDC program may be imposed if a state is found not to have complied substantially with federal requirements over successive periods. However, the penalty may be suspended if the state opts to take corrective action over a maximum period of 1 year, to come into substantial compliance. Improved interstate enforcement. The proven enforcement techniques discussed above must be applied to interstate cases as well as intrastate cases. Both states involved in an interstate case will be allowed to take credit for the collection when reporting total collections for the purpose of calculating incentives. In addition, the law authorizes OAKS to commission special demonstration grants beginning in fiscal year 1985, to be made available to states to fund innovative methods of interstate enforcement and collection. Federal audits will also focus on states' effectiveness in establishing and enforcing obligations across state lines. Equal services for welfare and non-welfare families. The Act amends Section 451 of the Social Security Act to provide that Congress, by creating the Child Support Enforcement Program, intended to aid both non-welfare and welfare families. In addition, the Act contains several specific requirements directed at improving state services to non-welfare families. All of the mandatory practices discussed above must be made available for both classes of cases. The interception of federal income tax refunds is extended to non-welfare cases. Incentive payments for non-welfare cases will be available for the first time. When families are terminated from the welfare rolls, they automatically must receive non-welfare support enforcement services without being charged an application fee, and states must publicize the availability of non-welfare support enforcement services. Other provisions. In addition to those provisions identified above, the Act requires that states, 1. Collect support in certain foster care cases. 2. Collect spousal support in addition to child support where both are due in a case. 3. Notify AFDC recipients, at least yearly, of the collections made in their individual cases. 4. Establish state commissions to examine, investigate, and study the operation of the state's child support system and report findings to the state's governor. 5. Formulate guidelines for determining appropriate child support obligation amounts and distribute the guidelines to judges and other individuals who possess authority to establish obligation amounts. 6. Offset the costs of the program by charging various fees to non-welfare families and to delinquent absent parents. 7. Allow families whose AFDC eligibility is terminated as a result of the payment of child support to remain eligible to receive Medicaid for 4 months. And 8. Seek to establish medical support orders in addition to monetary awards. In addition, the Act also makes the federal parent locator service more accessible and effective in locating absent parents. Sunset provisions are included in the extension of Medicaid eligibility and federal tax offsets for non-AFDC families.